I want to tell you about a Saturday morning in October that started with coffee on my porch and ended with a conversation that I have replayed many times since, not because it was dramatic. It was not particularly dramatic, but because it was the specific kind of conversation that happens when a situation has been building long enough that all the pieces are finally in the same place at the same time and everything resolves at once, clearly and completely. With the particular satisfaction of a problem that was always going to end this way, waiting patiently for the circumstances that would allow it to end. My name is Gwendolyn Price. I am 54 years old. I am a paralegal with 26 years of experience at a civil litigation firm in Henrico County, Virginia, which means I have spent 26 years reading legal documents, preparing discovery, managing case files, and developing the specific competency of knowing exactly what a document says and exactly what to do with it when what it says becomes relevant. I am not an attorney. I am something the attorneys I work with sometimes describe as more useful than an attorney in the specific situations where what is needed is not legal argument, but accurate documentation. Because accurate documentation is what I do and what I have done for 26 years, and what I am never not doing in any situation where documents and their accuracy might eventually matter. I live in Stonebrook Crossing, which is a 60-home HOA development in Henrico County built in the early 2000s. I have lived there 11 years. My property is an end unit in a townhome row, technically a townhouse in the legal sense, though it feels like a single-family home because the end unit has only one shared wall and has a private driveway that is longer than the standard unit's driveways due to the lot geometry at the end of the row. The driveway is entirely on my property. The deed shows this clearly. The HOA's recorded plat shows this clearly. My driveway is 12 feet wide and 41 feet long, and it is mine from the sidewalk to the garage, and I have parked in it for 11 years and allowed visitors to park in it and maintained it and repaved it once at my own expense, because it is my driveway and its condition is my responsibility. The additional property question is different and is the part that matters to this story. At the end of my driveway, past my garage, my property extends an additional 22 feet to the rear property line. This rear section, 22 feet of paved surface behind the garage, is not typically used for parking because it is enclosed on 3 sides by my rear fence and the development's perimeter wall and requires driving through the garage access to reach it. I use it for storage. Specifically, I keep a small garden shed there, some seasonal outdoor furniture, and a workbench my late father built that I am not willing to part with and that would not fit anywhere else. It is my property. It is clearly delineated on the plat. It is not visible from the street because of the garage and the fence. Nobody goes back there except me, which is how I prefer it. Unless someone parks a 42-foot Class A motorhome back there without telling me. Carol Danvers, not the Marvel character, just a woman with an unfortunate timing of name, moved into Stonebrook Crossing 5 years ago. She bought the end unit on the opposite side of the development, which had a similar property configuration to mine, longer driveway, rear section past the garage, and she had apparently, at some point in her first year, identified my rear section as a second RV storage option for when her own property was full. I want to be precise about this because it is the specific absurdity that makes the story what it is. Carol had a Class A motorhome, a 42-foot Tiffin Allegro bus that was worth, at the time of these events, somewhere between $250,000 and $300,000, and she had been storing this motorhome in a rotation between her own rear property section and my rear property section, apparently for approximately 3 years before I found out about it. 3 years, approximately. This is the number I reconstructed from the evidence, and I want to explain how I reconstructed it because the reconstruction is relevant to what happened later. I found the motorhome on my property on a Saturday morning in October. I had gone to the rear section to retrieve the folding chairs that I store there for use at the neighborhood fall cookout, which happened every year in late October and which I attended every year, and for which I always brought my own chairs because the community center's folding chairs were less comfortable and in varying states of disrepair. I went through the garage access, turned the corner to the rear section, and found 42 feet of cream-colored motorhome occupying essentially the entire usable portion of the rear section, with the front bumper approximately 3 feet from my father's workbench. I stood there for a moment. I looked at the motorhome. I looked at the workbench. I looked at the rear section in general. Then I took out my phone and took 22 photographs from every angle that was accessible to me, including angles that showed the motorhome's position relative to my fence line, my garage access, my shed, and my workbench. I photographed the motorhome's VIN plate through the windshield. I photographed the license plate. I photographed the wheel positions relative to my painted property line marker, which I had painted along the rear fence base 6 years ago when I was doing yard work, and had the survey fresh in my mind, and had thought at the time it was a useful thing to mark. The license plate came back registered to Carol Danvers of Stonebrook Crossing in Henrico County in about 45 seconds of a basic online registration lookup, which anyone can do with a plate number in Virginia. I had her name and address before I had finished my coffee. I went back inside and called my colleague at the firm, a senior attorney named Paul Whitmore, who specialized in civil property matters and who was the person I called when I needed to think through a situation before acting on it. Paul answered on the second ring because Paul always answered on the second ring, which was one of the things about Paul that made him an excellent attorney and an excellent person to call when you needed clear thinking quickly. I described the situation in the specific factual way that 26 years of paralegal work had trained me to describe situations: vehicle, dimensions, location, ownership, duration unknown but estimated significant. Paul said, "Gwen, is this the first time you found this vehicle there?" I said it was the first time I had personally observed it, but that I did not know how long it had been there. He said, "Before you do anything else, I want you to understand your options." I said, "Go ahead." Paul said my primary options were as follows. First, I could contact Carol directly and ask her to remove the vehicle. Simplest, fastest, and would likely produce the immediate result of the vehicle being moved. Second, I could contact a towing company and have the vehicle removed from my private property as an unauthorized vehicle, which was my right as the property owner. This option had nuances related to the vehicle's value. A tow of a Class A motorhome was not a standard tow, required specialized equipment, and would involve impound fees that would accrue until Carol retrieved it. Third, I could consult an attorney, him, for instance, about a civil trespass action that could produce damages. He said, "Gwen, option 3 is available if the duration of unauthorized use is significant, because trespass damages can include the fair rental value of the property for the period of unauthorized use." I said that was interesting. He said, "How long do you think it's been there?" I said I did not know yet. He said, "Find out before you do anything. The duration is the value." I thanked Paul and hung up. Then I thought about the duration question. My security camera had been installed 4 years ago, not because I had any particular reason to expect a problem. I had installed it as general home security, pointed at the garage access, because that was the logical position for a camera monitoring the rear section. 4 years of footage, stored on a 12-month rolling archive that kept the most recent 12 months and deleted older footage automatically. I had 12 months of footage available. I pulled the archive on my laptop. I ran it on fast forward, looking specifically at the rear section view. In 12 months of footage, Carol's motorhome appeared in my rear section on 14 separate occasions, ranging in duration from 2 days to 17 days. I noted the entry and exit times for each visit, the total days of occupancy, and the cumulative hours. The total authorized, I mean unauthorized, use of my property by Carol's motorhome in the 12 months of available footage was 63 days and approximately 8 hours. 63 days of a 42-foot class, a motorhome on my private property. I called Paul back. I gave him the number. He was quiet for a moment. Then he said, "Gwen, what is the fair market rental rate for RV storage in Henrico County?" I said I did not know off the top of my head. He said, "Find out. Because if the rate is, say, $15 to $20 a day for outdoor storage of a Class A motorhome, 63 days is between $945 and $1,260 in documented rental value loss just from what you can prove from the camera." I said I understood. He said, And if the duration before the camera record starts is significant, I said, Paul, she's been here 5 years. If the pattern goes back further than 12 months, he said, then you have a declaration under oath question. If she states the duration in a sworn document and you can prove a different duration through any other means, that's its own problem for her. He said, Gwen, prepare everything, all of it, and then call her. I spent 3 days preparing everything before I called. I compiled the camera footage into a summary document, entry date, exit date, duration, notes, for all 14 incidents. I researched RV storage rates in Henrico County using 3 different storage facilities' published rates, confirming that outdoor class, a motorhome storage, ran between $18 and $22 per day at facilities comparable to my property in terms of security and accessibility. I calculated the documented rental value at the midpoint of $20 per day. 63 days times $20 equaled $1,260 in documented loss from the 12-month period alone. I obtained a copy of the relevant section of Virginia Code governing trespass to real property and the calculation of damages. I printed Carol's vehicle registration, the VIN plate photograph, the license plate photograph, and all 22 property photographs from Saturday morning. Then I prepared a simple spreadsheet. It had the following columns: date of entry, date of exit, days on property, rate per day, value. At the bottom, it had a total row. I printed it in landscape orientation on a single page. Then I drafted a letter. The letter was 2 pages. It described the situation factually, the discovery of the unauthorized vehicle, the camera footage review, the documented incidents. It stated the applicable Virginia trespass statute. It stated the calculated rental value for the documented period. It requested the following: immediate removal of the vehicle, payment of the documented rental value for the 12-month period, a sworn written statement describing the full duration of the vehicle's use of my property, and an agreement never to park any vehicle on my property without my express written permission. It noted that if Carol disputed the calculation of the full duration, that dispute would be resolved in Henrico County General District Court, where the camera footage and the storage rate documentation would be submitted as evidence, and that in court, the calculation would include any additional period proven beyond the 12 months I had documented. I also noted, in the letter's final paragraph, that the HOA covenants at Stonebrook Crossing prohibited storage of recreational vehicles on residential properties, except in designated storage areas, and that I intended to file a separate covenant violation complaint with the HOA management company documenting the unauthorized storage on my property, which would create a record relevant to Carol's own property, should she be storing the motorhome on her own rear section as well during periods not visible on my camera. Paul reviewed the letter the morning I had finished the draft. He said it was clear, accurate, and legally sound. He said, Gwen, 26 years and you write better demand letters than most attorneys I know. I said, thank you. He said, send it certified mail, keep the receipt, and then wait. Don't call her, don't knock on her door, let the letter do the work. I said I understood that principle. He said, I know you do. That's why I'm telling you instead of explaining it. I sent the letter certified mail on Thursday afternoon. Return receipt requested. I tracked the delivery. The letter was delivered and signed for on Friday morning at 9:47. Carol called me on Friday evening at 6:15. I had been expecting the call. I had also been expecting that the call would contain some version of the explanation that people provide when they have been doing something they know they should not have been doing and have been caught doing it. The explanation that reframes what happened as something other than what it was. I had a notepad ready when the phone rang. Carol said, Gwendolyn, I received your letter and I think there's been a misunderstanding. I said, hello, Carol, what misunderstanding? She said she had been parking the motorhome on the rear section of her understanding that it was a shared common area behind the end units. I said, the rear sections of both end units are private property per the recorded plat. They are not common areas. She said she had not realized that. I said, Carol, the plat is in the HOA's records and available to any resident on request. My rear section is delineated on it. She said, I've only been doing it occasionally, not as often as your letter suggests. I said, my letter reflects my camera footage. I have 14 documented incidents in 12 months. She was quiet. I said, is that your position, that the 14 incidents documented on camera did not occur? She said, I'm not saying that. I said, then I'm not sure what the misunderstanding is. She said, I just think $1,200 is a lot. I said, it reflects the market rate for the storage I unknowingly provided for 63 documented days. If you believe the rate is different, I'm happy to discuss comparable facilities in the county. She did not respond to that. She said, what if I just pay for the current visit and we agree it won't happen again? I said, Carol, my letter describes the terms I'm prepared to accept. Those terms include the documented 12-month period, the sworn statement, and the agreement. If you want to propose different terms, please do so in writing and I will have my attorney review them. She said, your attorney? I said, Paul Whitmore at Whitmore and Associates. His contact information is in the letter. There was a pause. She said, I'll need to think about this. I said, of course. The motorhome is still on my property. I would appreciate removal within 48 hours, regardless of how the financial question is resolved. She said she would have it moved tomorrow. I said thank you and ended the call. The following Monday, I went to Paul's office, not because the situation required it yet, but because I wanted to think through the next phase with someone who would tell me honestly whether I was proceeding correctly. Paul had the capacity to tell me when I was wrong that most people in my life did not exercise as freely as he did, which was one of the reasons I had worked alongside him for 16 years and trusted his judgment in situations like this one. I told him about the phone call. He said, she disputed the frequency. I said yes. He said, she'll be back with a counteroffer. What do you want? I said I wanted what the letter said I wanted. He said, the sworn statement is the interesting piece. You know why? I said I had a theory. He said, tell me. I said, if Carol provides a sworn statement describing the full duration of the use, and that statement claims a shorter duration than the evidence suggests, it becomes a false statement under oath, which is its own problem. If it claims the full duration accurately, it establishes a damages period significantly larger than 12 months, because she had been in the development for 5 years and the pattern I had documented from 1 year's camera footage was regular enough to suggest it had been going on longer. Paul said, exactly. The sworn statement is either accurate, in which case it gives you the full damages period, or it's inaccurate, in which case it gives you a different kind of leverage. He said, what do you believe the full duration is? I said I believed it went back to at least her second year, possibly her first. He said, what would the damages be at $20 a day if it was 3 years of the same pattern? I pulled out my phone. I said 14 incidents in 12 months at an average of 4.5 days each was 63 days. 3 years would be approximately 189 days at $20 a day, $3,780. He said, and if it started in her first year, I said 4 years would be approximately $5,040. He said, you said $20,000 in your title for this story. I said I had not said any such thing. He said, hypothetically. I said hypothetically, the number could reach 20,000 if the full duration was substantially longer than I had documented, and if the court applied a multiplier for willful trespass, which Virginia allowed in cases of knowing and repeated unauthorized use of another's property. He said, that's a real outcome if she disputes the claim in court and loses. I said yes. He said, does she know that? I said probably not yet. He said, when she comes back with a counteroffer, let me be the one who explains it to her attorney. She came back Wednesday with a counteroffer. Her counteroffer was delivered not by Carol directly, but through a letter from an attorney named Stephen Garrity, who practiced general civil law in Henrico County and who had written a competent and reasonable letter proposing a settlement of $400 as full resolution of the matter, on the basis that $400 represented the cost of 3 recent visits worth of storage at the documented rate. The letter also said Carol disputed the frequency of use prior to the 3 most recent incidents. I forwarded Garrity's letter to Paul. Paul drafted a response. The response was precise and specific. It addressed the frequency dispute by noting that the camera footage documented 14 incidents in 12 months, not 3, and that the documentation would be submitted as evidence if the matter proceeded to court. It addressed the calculation by reiterating the 63-day documented period at the $20 daily rate, producing $1,260. It then noted, and this was Paul's addition rather than mine, that in a Virginia Circuit Court action for trespass to real property, the plaintiff was entitled to request the court apply a willful trespass enhancement to the damages calculation, and that the 14 documented incidents over 12 months, each of which had occurred after the pattern of use was established, and which therefore reflected knowing and intentional use of another's property, were precisely the kind of conduct the enhancement was designed to address. The enhancement could produce treble damages 3 times the base rental value in cases where the trespass was found to be willful. The letter calculated treble damages on the 12-month documented period at $3,780. It then noted that if the court found the pattern extended to the full duration of Carol's residence in the development, 4 years, the base damages would be approximately $5,040, and the treble damages would be approximately $15,120. It said Paul's client was prepared to settle the matter for the documented 12-month period at base rate, $1,260, plus legal fees of $800, for a total of $2,060, provided Carol executed the sworn statement and the agreement described in the original demand letter. It said if the matter proceeded to litigation, the settlement offer would be withdrawn and Paul's client would seek the full available damages, including the willful enhancement and the full duration period. Stephen Garrity called Paul the day he received the response. I know the character of that call from what Paul told me afterward. Paul said Garrity had said, "Paul, your client is a paralegal, isn't she?" Paul said yes. Garrity said, "She prepared this herself." Paul said he had reviewed and finalized it. Garrity said, "The treble damages argument is solid." Paul said he agreed. Garrity said, "My client didn't understand the exposure." Paul said most people didn't, which was why legal advice was valuable. Garrity said he would be back in touch. He was back in touch 3 days later. Carol had authorized a settlement of $2,060. She would execute the sworn statement and the agreement. The sworn statement described the use as beginning in her second year in the development. She had apparently decided to be accurate, which was the correct decision, and which meant she had confirmed 3 years of the pattern rather than the 1 year I had documented. The sworn statement showed approximately 189 documented use days over 3 years. I executed the settlement agreement, received the payment, and filed the sworn statement and agreement with Paul for my records. I also filed the HOA covenant violation complaint, as I had said I would in my original letter, which documented the unauthorized RV storage on my property and noted the recording of the settlement agreement as evidence of the prior unauthorized use. The HOA management company acknowledged the complaint and sent Carol a courtesy notice, noting that RV storage on residential properties required use of the HOA's designated storage area, which was a small secured lot at the back of the development that the HOA maintained specifically for this purpose, and which Carol had apparently never used in 5 years of owning a Class A motorhome in an HOA development. The filing of the HOA complaint had a secondary effect I had anticipated but not relied on. The HOA's management company, a firm called Richmond Property Group, conducted a review of Carol's own property in response to the complaint and found that she had also been storing the motorhome on her own rear section on a rolling basis, the same configuration as mine, unauthorized under the same covenant provision. She received a formal covenant violation notice for her own property. The notice required her to remove the motorhome from her property to the HOA's designated storage area or to an off-site commercial facility within 30 days. She complied. The 30-foot lot at the back of Stonebrook Crossing that had previously been invisible because nobody had needed it was now occupied by Carol's 42-foot motorhome, which was visible over the perimeter wall from the interior road. This was, I was told by 3 separate neighbors over the following month, a point of some conversation at the development. I did not attend those conversations. I had been at the fall cookout, which had been exactly as it always was, neighbors and food, and the particular pleasantness of an outdoor event on an October afternoon when the leaves are changing and the air is cool. I had brought my folding chairs from my rear section, which now had the workbench and the shed and the seasonal furniture and the full 22 feet of paved surface that had always been mine, and that was now, additionally, documented as mine in a sworn statement and a settlement agreement and a covenant violation record, all of which were in my files and would remain there. Paul came to the cookout. He came every year. He filled a plate and found me near the back fence and said, "Did you bring your chairs?" I said I had. He said, "From the rear section?" I said yes. He said, "How does it feel?" I said it felt like a rear section. He said, "It does. It feels exactly like a rear section that belongs to you." I said that was correct. He said $2,060 for 63 documented days and a settlement that extends the record to 3 years. I said yes. He said, "You know what the actual number would have been if she had decided to litigate and you had gone to court with the full 4-year exposure and the willful enhancement?" I said I had calculated it. He said, "Tell me." I said 4 years at the patent rate was 252 days. At $20 a day, that was $5,040. Trebled for willful trespass was $15,120, plus legal fees and costs, reasonably estimated at $4,000 to $6,000. He said, "So between $19,000 and $21,000. I said, "Roughly." He said, "She settled for $2,060. I said, "Yes." He said, "That was the right decision for her." I said I knew. He said, "Did you want her to litigate?" I said no. I said I had wanted a documented resolution that protected my property going forward and compensated me for the documented period, and that was what I had. He said, "The 20,000 would have been more satisfying." I said the 2,060 and the sworn statement and the agreement and the covenant violation record were more permanent. He considered this. He said, "Fair." He went to get a second plate. The motorhome has not been on my property since the Saturday it was moved. I check the rear section when I use it, which is regularly, because my father's workbench is there and I use it. The paved surface is clean and undisturbed. The shed is where it has always been. The workbench is exactly where my father put it, which is where it belongs. The settlement agreement is in my files under T for trespass, which is the category I use for property rights documentation, which I maintain with the attention I bring to all documentation, which is the attention of someone for whom documents are the medium through which rights exist and are protected and are preserved against the comfortable assumption of people who believe that using something for long enough makes it theirs. It does not. What makes something yours is the deed and the plat and the accurate record and the willingness to read them carefully and act on what they say.